So when you're getting ready to go into mediation, it's extremely important to first have sat down with your attorney to understand what you're likely to win in court and what you're not likely to win, to have realistic expectations about what's going to happen in the court and what you should definitely not give up. In other words, sometimes people in the mediation process give away things that they should not be giving away just because they want to end the case. And I understand it is important often to resolve the matter in an expeditious manner, to save fees, and to reduce the emotional fallout of the case. But if there's something important that you're going to give up, that otherwise you're going to live with for the rest of your life, or for many, many years in the future, and not be comfortable with, then it's important to understand what your chances are of winning or losing that before you go into mediation. So mediation runs parallel to the litigation process in divorce. And mediation, it's important to understand, is optional. Neither party has to either go into mediation or accept the result that comes out of mediation. So when we look at what's going to happen in court, because court is where really the power, the authority of the case exists, we have to understand how mediation is going to fit into the broader context of the case. Because at any point, either side could say no and just step aside and continue with litigation. So we have to understand mediation in the context of the broader litigation and understand with you and your attorney how mediation is part of the broader strategy in the case. If this doesn't happen, then you're likely to not get the result that you want in mediation. In other words, before we go into mediation, we always have clear, myself and my client, what's the only way we could really mess this up with regard to the broader case. So it's essential that you and your attorney are on the same page with regard to strategy and the broader context and how mediation fits into the litigation. To go into mediation without having properly completed discovery, that is to say, the complete comprehensive disclosure of documents and understanding of what is at stake in the divorce process, of what's on the table to be split up, is really to go into mediation blind or with one hand tied behind your back. It's really risking wasting the mediation process and thousands of dollars potentially of time by mediators and attorneys that otherwise should not have happened, or at least should not have happened yet in the case. Because imagine you go through mediation and you come up with something that you think is a good agreement, assuming that you understood what the proper financial picture of your spouse was. But then after mediation's over, you find that there's a treasure trove out there that you didn't know actually indeed existed. So that's going to change the entire process of the negotiation. It's going to change the whole texture, the context of what's on the table. There's something else now to split up that might totally affect everything that you agreed on already. Why do that? Why waste that time, money, and emotional expense? You should ensure that you've completed discovery thoroughly, completely, prior to entering into the mediation process. On the day of mediation, it's really important that you've got no distractions, that the kids are taken care of, that you've got the day off from work, that you've done your proper due diligence on your own account, whether it's meditation or prayer, whatever you do, talking to your close friends, whatever it is that's going to give you that emotional energy, that confidence, that peace of mind that's going to allow you to go into the mediation with focus, with confidence, and with a positive attitude. If you're going in with a cloud over your head, or you're going in tired, depressed, anxious, upset, of course, always, these emotions are often there to some extent, but you don't want them to be controlling, right? You want to be in a place where, for example, in internal family systems, psychotherapeutic modality, we talk about being in a place of self, of the 9 C's, of being in a place of calm, of confidence, of choice, of courage, of creativity, of compassion, connection. We want to be in a good place where we're ready to deal with all these important and sensitive and often difficult issues that we're going to have to grapple with during the mediation itself. These have been steps to prepare for your mediation process by your friends at khk Family Law Attorneys. Don't hesitate to reach out to us for your free consultation.